When sex offenders move from another state to New York and have to register for 20 years, can they get credit for some of that time in the state they came from? To find out, you have to read People versus Corr and McDonald, but it's 34 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. This is the episode on the case of People versus Corr and People versus McDonald. Two cases joined together. The citation for this case is 2024 New York Slip Opinion 03379, published by the Court of Appeals on June 20th of 2024. The issue in this case is whether sex offenders that move to New York get credit for time served as registered sex offenders in their previous states when calculating the amount of time they have to serve and as registered sex offenders in New York. The background law that's helpful to understand and appreciate the context of this case is Corrections Law 168, which is where New York's Sex Offender Registration Act is found. We call it Sora, S-O-R-A, Sex Offender Registration Act. And under Corrections Law 168-H1, it talks about how long a sex offender has to be registered for. And it states the duration of registration and verification for a sex offender who has not been designated a sexual predator or a sexually violent offender or a predicate sex offender and who is classified as a level 1 risk or who has not yet received a risk level classification shall be annually for a period of 20 years, and this is the important language, from the initial date of registration. So it's 20 years from the initial date of registration. That's the background law that's helpful to appreciate this case and approach it. The facts are, these are two different people, Brian McDonald and Matthew Corr. They have separate cases, but they're joined because it's the same issue that's being presented. Brian McDonald was convicted of a sex offense in the state of Delaware, a felony for which he was required to register as a sex offender. In August of 2015, that's when he was registered initially as a sex offender, but then he moved to New York. He was found to be a level 1 sex offender and required to register for 20 years in New York. He requested by the judge doing the Sora hearing that the date he initially registered in Delaware be calculated and included in that 20-year period, because the initial date of registration, according to him, was the date he was registered in Delaware. The court denied the request. Same situation with Matthew Corr. Matthew Corr was convicted of a sex offense in Rhode Island. He relocated to New York, and when it went to the judge doing the Sora hearing, he was found to be a level 1 sex offender and required to register for 20 years. He, just like Mr. McDonald, said, okay, 20 years from the initial date of registration, let's talk about when I was registered in Rhode Island, and I want credit for that. And the judge denied it, and it goes to the appellate division for each of these cases, and they affirmed what the judge had done in each of these cases, and it goes to the Court of Appeals. And here, the question is a statutory question. It's a question of statutory interpretation. Does the phrase initial date of registration, what does that mean? Does it mean when the initial date of registration in New York or the initial date of registration wherever in the world that person initially registered as a sex offender? This is a contentious decision. There's 3 different decisions here. There's a majority written by Judge Troutman, joined by Garcia, Singas, and Canatero. That's 4 judges, the majority. There's also 2 different dissents, one by Rivera, joined by Judge Wilson, and one separate dissent by Judge Halligan. And essentially, the majority decision here, the majority is that reading the statute as a whole, okay, the statute refers to when first registering under Corrections Law 168. It specifically says a sex offender is required to register under this article being Corrections Law 168. It acknowledges. So basically, the majority says it doesn't matter how many years you've served elsewhere. If you're registering in New York as a sex offender and you're level 1, then it's 20 years, and it's 20 years from the date you register in New York. So they acknowledge this may be unfair. Let's say a person comes from a state where there's also a 20 years requirement, and they register for 11 months. They registered for 19 years and 11 months in the other state, and then they moved to New York. If they had stayed where they were, 1 more month, they'd be done. But by coming to New York, they now have to register for a new 20-year period, which is a total of 39 years, right? That's obviously not necessarily fair, but that's the reading of the statute according to the majority. The dissent says the opposite. The dissent, written principally by Judge Rivera, says the statute talks about a temporal. They say the initial date of registration. They don't say where in the world it is. They don't say initial date of registration in New York, like some states do. And by saying initial date of registration, that should mean wherever they registered. So it shouldn't be that you should be able to get nunc pro tunc, which means credit, as of the date you initially registered in the foreign state. But once again, that's the dissent. The majority here, the holding by the majority here is that it's 20 years from the initial date of New York registration, not wherever you initially served your registration. And that's the case of People versus Corr and McDonald. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.